Hello viewers, welcome to another exciting episode of our Q&A session at Lex-Praxis. My name is Uyubong Jonad. I'm a legal associate with Lex-Praxis Solicitors. On today's episode, we'll be talking about how to register a trademark. So in view of the recent occurrence in the business world, we find that Zap Africa is alleging that Paystack has infringed on their trademark, right? And Paystack, on the other hand, is coming out to refute the claim that they have actually registered ZAP, the name ZAP, and also the logo in multiple classes of trademark, including financial affairs, aspects, and monetary affairs. So we'll be examining all of this by addressing how you can register a trademark. I'm not alone. I have with me the principal of Lex-Praxis Solicitors in the person of Cynthia Tishon. You're welcome, Ma. Thank you very much for joining us on today's episode.
Hello, Yvonne. Hello to everyone that's watching this video. It's a pleasure to be here once again.
All right. Let us dive into the business of today. So, what is trademark? I'm sure a lot of people trademark it. So, can you please enlighten us on what trademark is?
A trademark is a form of intellectual property rights that is given to the owner of either a name or a unique set of phrases, a slogan, or logo, right? So, trademark, when people have those kinds of unique name, brand, phrase, slogan, or logo that they want to protect, they protect it through trademark registration. Just like we have other kinds of intellectual property protection, which include copyright registration, patent registration, a trademark registration is one of the rights that will be afforded to people who want to protect um, their rights in that category. Yeah.
All right, all right. Thank you for that detailed explanation. So now we want to consider the registration process. Give us a rundown of what the registration process is like.
Okay, so basically, there are various stages to trademark registration in Nigeria. The first phase of that process is to conduct a search, a name search. So if you have a name that you want to register as a trademark or a slogan or a set of words that you consider is worth protecting under trademark registration, you carry out a search to find out if the name has already been registered in the particular class or set of classes that you want to register. Now, once that is confirmed, if it's confirmed that the name has not been registered and you've been given the go ahead to proceed with your application, the next step is to submit an application to register this particular name or slogan. Of course, you could register a name and a logo or what they call a device together, right, in your application, right? So you submit that a formal application is submitted. Normally, this is done through a certified trademark agent, right? So once the application is submitted, you get a letter of approval, right, to proceed with the name, to register that name. Like it's a kind of it's considered as a face value or prima facie evidence of registration. So you get an acknowledgement letter, right, from the registrar of trademarks acknowledging the use of that name and or device or logo in the particular class or set of classes that you want to register. Now, I made reference to the fact that the letter acknowledgement letter is considered as prima facie evidence. Why is it so? Because when you consider the next phases, which I'm going to be dealing into, you have the publication phase. Now, after you have the letter of acknowledgement from the trademark registry, there is an acknowledgement, there is a publication that is supposed to be issued by the trademarks registry. to give room for the members of the public to take note of that application, of your pending application. This will enable anyone who has any objection to the approval of your name, your proposed name or logo or device, to raise their objection. It's just like when you're getting married and they say, if anyone, does not consent to this marriage, you show your hands, indicate now, forever hold your peace. So that's what that publication does, right? So the publication is issued for a period of time. And after that, if there is an objection that is being raised by anyone, the objection is heard at the trademark registry, and upon considering all the evidence before it, the trademark registrar can decide to either discontinue with your application or ignore the notice of objection that has been raised by any third party. Where there is no objection raised with regards to your application, the next phase is the final phase, which is receiving of your final trademark certificate. Now, back to the second stage of the registration, I talked about the acknowledgement letter, which is considered as the prima facie evidence. Generally speaking, from the acknowledgement phase to the final certificate, it could take up to 6 months to 1 year in Nigeria, in practice, to get your final certificate. So by reason of that, the acknowledgement letter is actually considered as face value evidence of registration of the trademark, right? And even because of the complexity of time that comes with actually getting the trademark registration certificate, most government agencies also recognize the acknowledgement letter as evidence of trademark registration. So agencies like NAFDAC, right, they recognize your acknowledgement letter. If you're trying to maybe register a product with NAFDAC, of course, one of the requirements is a trademark registration, right? Proof of trademark registration. And so you can present the acknowledgement letter from the trademark registry as face value evidence for registration of your trademark. I hope I've been able to explain the process.
Yes, very well. Thank you so much. So now that we've considered the subject of the duration, because while you were explaining, you mentioned that it takes about 6 to 1 year in practice to be able to obtain the certificate of trademark. And you
Six
also
months to one
mentioned
year.
that the letter of acknowledgement, yes, 6 months to. So does it expire? I mean, the trademark, after you've gotten your certificate at the end of the day, does trademark expire? If it does, is it renewable?
Yeah, okay. So your registration, your initial registration lasts for a period of 7 years. So you have that right to the registered trademark for a valid period of 7 years. Now, after 7 years, you are required to renew your license. And once you renew it, you are entitled to another 14 years, right? Your trademark rights is extended to another 14 years period. So yes, your trademark expires. There is a duration. And so it behoves on you to look out for that and make efforts to renew your license or your trademark rights or registration upon expiration.
All right. Let's cover the field a little. Let's cover it all. What um you mentioned that you have about 6 to that after the expiration. What happens? What happens after the trademark expires? Because a lot of people, especially business owners, they still continue in business without knowing the effect of that expiration. So what happens upon expiration? Does it return back to the public, or can business owners still come out and claim that, okay, I have trademark this name or logo? So let us consider the
So technically,
consequences.
okay. So technically speaking, Once the trademark date duration expires after 7 years and you do not make any attempt to renew, you leave that access to that name open to members of the public, right, to proceed to make use of the name. So if your license is, if the registration validity period expires and you've not made any attempt to renew, what happens is that anybody can use it, anybody can use the name or the logo or device in that class going forward. But if you make attempts to renew it, then you still maintain exclusive ownership rights to either the name, the logo, or the slogan, as the case may be, in that device or in the class rather in which it was registered.
All right, so we can rightly conclude that upon expiration, if you fail to renew, it goes to the public. Anybody can claim ownership of that name. So that means that at that point, somebody cannot bring an action claiming that there was an infringement of his trademark at that point.
Very likely, very likely.
All right, so looking at the recent occurrence between Paystack and Zap Africa, Paystack is claiming that they registered the name Zap and also the logo in multiple classes. So, how many classes do we have under the trademark registry? And also, this is a two-in-one question. Is it possible to register if, let's say, there are five classes? Is it possible to register in all five classes, or are there limits to the number of classes that one can bring, can register his or her trademark?
Okay, so under Nigerian law, um, our trademark laws categorizes our trademarks into 45 classes. So we have classes 1 to 34 covers goods, right? Tangible goods or products, while classes 35 to 45 covers services. So those are the various categories or classes we have under trademark. So going to your second question, it is very possible to register in as many classes as possible. In fact, we advise our clients to register apart from the class that concerns or pertains to them, right? Or pertains to their sector. It's important to also take extra steps to also register the trademark in other classes, especially if you're very, very keen about exclusivity. Because truth of the matter is that when you're registering a trademark, you register in classes, right? If you register in class 1, for instance, which relates to your sector, that means that you only have ownership or rights to use that name or logo only in the class 1, in the goods that are available in class 1. Another person can still use the same name and logo in class 2 to 45, right? So that is the unique situation that comes or happens when you're facilitating a trademark registration. So that's why we advise that if you want to take maximum advantage of the exclusivity that trademark registration affords you as it concerns your brand name, your logo, or slogan, you should make attempts to register in as many classes as possible, apart from the class that relates to your sector.
All right. So, considering our case study that is between Paystack and Zap. So if Paystack comes out to say that, hey, we registered in the financial affairs, monetary affairs, and estate insurance, and then they leave the other classes open. So can Zap come out to say, okay, you registered in those classes, or we have registered in these other classes? Can they maintain that sort of claim against Paystack?
Yeah, if Zap Africa has registered in other classes. Now, let's even talk about the registration, right? we made reference to the phase and the stages of registration. So it's also possible. The first question we need to ask is, when you say you're registered, at what phase did you register to the stage of obtaining the final certificate, or you just have the notice
Letter
acknowledgement
of
letter
acknowledgement.
from the trademark registry? Because that's another thing, right? Now, the thing is that when you have just the acknowledgement letter, you said yes, that is face value evidence, but it's not conclusive. That is not the final registration. Yes, you can use the TM, the TM signature. You can attach that sign to that brand, to inform the public that you are in the process of the registration. And then when you obtain the final registration, you have that R mark, right, that says it's registered. So that's the first thing that needs to be addressed. So when they say they registered in all these classes, or if any of them is claiming, we need to know to what extent did they register to the point of final certificate, right? So if Paystack claims that they registered, let's assume that they have actually registered in all these classes and they had the final certificate, right? ZAP Africa cannot, ZAP Africa is automatically restricted and barred from using the said name or logo or slogan, right? As it concerns those classes. I don't know if you get my point.
Yes,
So
ma'am.
if on the other hand, ZAP Africa has gone ahead of Paystack and concluded their registration down to the final certificate stage of their trademark application with respect to the same class that Paystack is laying claim to, then what that means is that Paystack has no right to use the said name, ZAP, in question, right? However, if Paystack has registered in a separate set of classes, they did not say in all the classes, they just said in most of the classes, right? If they registered in separate classes and ZAP Africa
Yes.
has also registered in other classes that is different from the classes that Paystack is laying claim to, then, well, technically speaking, ZAP Africa is actually restrained from using the said phrase to the extent of the classes that Paystack has registered, whether it's the acknowledgement phase or the final phase, the final certificate phase, right? And then that goes the same way with ZAP Africa. Paystack is also restrained from using ZAP, the word ZAP, to the extent of the classes that ZAP Africa has registered. But here's the interesting thing. Both ZAP Africa and Paystack are financial service providers. They are operating within the financial sector. Right? The main disputes will not even have to do with trademark in other classes. It will have to do with the particular class that covers the financial services, right? So based on that premise, if Paystack, right, has registered the word ZAP in question in the class that relates to financial service, right, and then completed it down to maybe the certificate stage, right, then Paystack will have the upper hand here. But if
Yes.
ZAP Africa has also done the registration in that same class and has not gone to, because it's not possible for both of them to apply in the same class and they will both have the final registration. That would mean there's an administrative issue, but I strongly doubt that, right?
Yes.
So if that Africa has not registered down to the final stage, or they have not even registered in that particular sense at all, then South Africa cannot have the upper hand in this situation, right? So I hope I've been able to answer that question. I know we explained a lot here,
Yes,
but I think it's better.
we've done justice to it. Thank you so much. All right, let us consider
Thank you.
the registrables and non-registrables. Like, what are the things that are allowed under trademark? What names are allowed? What logos are allowed? Let's consider them.
Generally speaking, if your trademark has to be successful, it has to be a name that is not, of course, cannot be similar or sound similar to an already registered trademark. It cannot be a generic word. It can't be a generic word in any case, right? So it has to be a unique set of words that cannot be used or cannot be easily be used by anybody. For instance, you cannot say Calabar to the world is registered as a trademark. I mean, Calabar is a state. The world is a generic word. That means the implication of that, if it's registered as a trademark, is that you'll be restraining people from or restraining anybody from making use of the word Calabar and world. And how is that possible? Right? Another point to take note of, the third point is that if it is in a sector, you cannot register a technical word, like maybe if it's in an engineering sector or maybe the legal sector, you can't register a word or a slogan that is very common in a particular sector, right? So um, let's say in engineering, you say something engine, right? Or zap
Yes.
engine or tochi engine. In engineering, I mean engine or mechanism, something like that.
Yes,
It's
it's a common
expected that
word.
anyone within that sector it has to be used. So you cannot restrain your other colleagues from using it because you got the idea to have a trademark, right? So at least these are the 3 points that you should take note of. And for other points, of course, your professional, whoever is helping you with this process, will be able to advise you properly.
All right. Um, Let us wrap up by giving business owners some tips and tricks. So, what are your last words to business owners? Let's say someone wants to register his trademark today. What is your advice to such a person?
Okay, so yeah, the general question I get is okay, so I've had my business registered, and then why am I doing a trademark registration? Is it not almost the same thing? The truth of the matter is that the benefits and the privileges that a company formation or registration or a trademark registration gives you are totally different. When you register a company, either a business name or a limited liability company, all you are just getting is legal recognition. So you are being recognized by the government of the day or by law. You are being recognized and authorized to do business in the name that you've been registered. You have the benefit of, if it is a company, you have the privilege of operating as a separate legal entity. That company is a separate legal entity, right? But a trademark registration does something totally different. When it comes to using your name, the brand, the logo that is associated with you, that people know you for, what trademark registration does is that it gives you exclusivity. No other person can use the same name to do business. Even right, the same name that you are actually known for. Because in most cases, the chances are that maybe the name is already registered or is not even available, right? But if it is, just take example, we have a platform called Remita. Everybody knows Remita, but do you know that Remita is just a trademark? Do you know that Remita is a that is owned by a company called System Specs Limited? Now, who knows System Specs Limited? All we know is, Remita, right? So at the end of the day, System Spec Limited is not popular. What they know is the product. So that's the benefit. Nobody can register a name that is registered as a trademark, right? But it's very possible that someone can use a name that is registered as a company and register it as a trademark. So in terms of being the owner of your brand name that people know you for, that is what trademark registration does for your brand. So yes, I know that yeah, there are registrations to be done as a business owner, but you have to look at the long-term benefits when you compare or measure the requirements, registration requirements, and this is expected globally, right? So just focus on the long-term benefits and do what needs to be done. You don't need to wait to become a celebrity until you remember. It's not difficult in this day and age of social media to become very popular and to become famous, right? And so you don't need to wait for that time before you start taking measures to secure your brand. Lay the proper foundation, have your business registered, have your trademark secured, every intellectual property asset, have it secured so that when you come into the limelight, as you begin to get known and famous, you know that you've already done your homework and you're protected from the word go.
All right, thank you very much for that detailed advice. Viewers, I hope you have heard her. I told you that this session was going to be informative. So for our business owners, please consider taking these steps that we have listed and the advice that we have given in the course of this session. Um, if you have any questions, please leave them in the comments section and we'll reach out to you. But in the meantime, you can like our page, follow us on all our social media handles, subscribe to our YouTube page, and yes, we'll reach out to you if you have any questions in the comments section. So we come out your way next time. Have a great day. Bye bye.
Bye.